Good afternoon or good evening, whatever time you're joining us. My name is Helen O'Sullivan and you're very welcome to this short lecture on the City College's Property Law FE1 Night Before Notes. And this lecture is, of course, to accompany the Night Before Notes that are available to the public through the City College's website. And really the purpose of this lecture is quite simple. It is to go through some topics, 3 in particular, just to show the standard upon which you'd be expected to answer in the property law exam. We've gone with 3 very popular questions here that we're going to go through. And generally speaking, what you should try and realise throughout this lecture is, am I meeting that standard when I'm answering a question? In terms of a problem question, if you get a problem question and you have any idea of what's written in the examiner's reports, you'll be very au fait with the words the ILAC approach. The examiner, as with all examiners, is very vigilant of students who are not using the ILAC approach. The ILAC approach is something we engage solely for a problem question. ILAC, of course, standing for the issue, the law, the application and the conclusion as set out in the slides there. So the idea is that in a problem question, you will write a short introduction, just introducing your client. So remember, it's not an academic answer. You are expected to answer to a real life client. And thereafter, you'll set out what your issues are. Now, that does not mean you write all the issues in one paragraph, then the law for all those issues in one paragraph, and then the application of all the law for all the issues in one paragraph, one solitary conclusion. That's not what we're looking for. What we're looking for is a short introduction. Then you'll state in your second paragraph what your first issue is that you're going to discuss. You write the law out in relation to that issue, apply your client's facts to the law of that one issue. Write a 1 or 2 page conclusion on that one issue, move on to your second issue within that question. So just be very, very strict with yourself on the ILAC approach. It's probably the easiest marks you're going to get is for the structure and being quite clear and precise and concise. The first question that we're going to look at today relates to the question of finding. Finding is a very popular exam question, and when it comes up on the paper, it's really well answered because students quite like the topic. So why not do it today? Now, when finding comes up on the paper, it's often been a problem question. It's not outside the realms of possibility for it to be an essay question, but it's a problem question more often than not. There's loads of different variations of this question, but this is something very similar to what we've seen consistently in the exam, despite the fact that it's 2011, this particular question. So don't let that deter you. On Friday evening, while out exploring with his dog on his father's land, 12-year-old Simon, so just note his age there, discovered a hidden entrance to a cave which is accessible from both his father's land and that of his neighbour, Mr. Burns. Simon and his dog walked over the cardboard sign on the ground which read, "Keep out no trespassers." However, Simon and the dog carried on regardless, ventured further into the cave. After a few minutes, Simon discovers a gold brooch and some other pieces of old-fashioned jewellery, which were half buried in the ground. Now, those words, half buried, are really, really important. And we see that or something similar to that come up time and time again in relation to a problem question on finding. So just circle those words. He wiped off the mud and saw that on the back of it there was an engraving, "All my love to my dearest T, always and forever." Simon dropped the brooch and the other artefacts in his pocket of his jacket. Just then, Tim, who had sold Simon's father the land 10 years previous, appeared in the cave with Simon's father and claimed he should have the find as it belonged to him and advised the parties who was entitled to the brooch. So, something just before we get into it that a lot of students did not pick up on when this came up on the paper is that Tim, who's the prior owner of the land, may well be Mr. T, who is described as "my dearest T" on the back of the engraving of this particular artifact. So just bear that in mind and the implication of that. So we're engaging the ILAC approach, and before we get into issue 1, we're writing a short mini introduction to the parties. And I want you to think, how do I make these clients care about the law of finding? How do I make it relevant to them? And you can only do that in a few sentences, and they're usually straightforward, direct sentences. How does the man in the 46A come to care about the law of finding? Only if it applies to him. So you set out that the law of finding, generally speaking, allows parties who are not the actual owners of the property to have the best title to the property. The gold brooch and the jewellery doesn't seem to belong to any of the parties concerned. That may not be the case, but you can flag that. And a question arises over who has the best title to the property. But, and it is often worth saying this in your introduction, the law of finding is only applicable in a situation where the true owner is not forthcoming. And we have to pose the question, therefore, who is T? And T might be right underneath our noses this entire time. If the true owner, which Tim says he is not forthcoming, then we must engage the doctrine of finding. So you've instantly provided a bit of context there, just to say from the outset, what we're about to discuss is solely relevant if the true owner is not Tim. Issue 1 then is, were the items that Simon has found ones of national importance? Now, I don't want you to write issue 1 equals in the exam. These are slides, so these need to really reflect real life advices. You wouldn't hand a client back an exam paper that says issue 1 equals are the items one of national importance. You need to work that into a sentence format. The relevant law here is, at common law, it was understood that all treasure trove, now we don't really use that word as much anymore, but all treasure trove belonged to the state. And post the introduction of the 1937 Constitution and the introduction of a republic, the question as to whether those royal prerogatives wherein the Crown would have the best entitlement to items of national importance or treasure trove survived the enactment of the 1922 Constitution and the 1937 Constitution. And Webb v Ireland is a case that you may have come across before because it's a well-cited decision in constitutional law and also anytime you're discussing the doctrine of legitimate expectation. So this is the famous case where Mr. and Mrs. Webb entered the premises of the Derry-na-Flan Church. Obviously in the manual there's more descriptive detail there in relation to that particular case. And ultimately they found the Derry-na-Flan hoard, which can be seen today in the National Museum. It's clearly now, as you and I well know, items of national importance. But when the decision went to the Supreme Court, the issue was, does the doctrine of treasure trove survive the Constitution? The Supreme Court said, yes, it does, because what we can say is under the 1937 Constitution, the people, the state, are sovereign, and therefore the state has a right to items of national importance. So treasure trove now is kind of developed a bit. It's now considered to be items of national importance. It doesn't need to be gold and bullion or silver, which it would have typically had to have been. So we get a more expansive definition of treasure trove. And then again, where the Webbs really won out here was they had effectively successfully argued, by the way, in the Supreme Court that they handed over the Derry-na-Flan hoard because they had a legitimate expectation that they were going to be handsomely compensated. And in their eyes, they weren't. And the Supreme Court agreed with them and awarded a higher level of compensation. The other thing to flag here with Webb v Ireland is they were trespassers. And we'll come back to that in just a second, but you could discuss that here if you wanted to. In applying the law, being Webb v Ireland, to our facts, Simon has found a gold brooch. We know, well, all we really know is that it's an old-fashioned piece of jewellery. We need further particularisation of that. We are not archaeologists, we are not experts in this field, and even if we are, we aren't for the purpose of this exam, so we aren't going to draw any conclusions on that. We're basically going to put it back in the client to say, the law says if it's an item of national importance, the state will have a better claim to it, not Simon, the state. Again, this only applies if the true owner is not forthcoming. We need further inquiries, but if it is one of national importance, it is the state that shall have the best claim to those items. Moving on then to the issue of trespass. Now, you could have discussed this here or at the very end. I'm just discussing it here. Webb v Ireland, while the Webbs had the permission to be on the grounds of the Derry-na-Flan Church, they did not have permission to dig up the ground. Therefore, they become trespassers in that instance. Now, it's not what the court called a flagrant act of trespass. It's quite a low-level act of trespass. So as a matter of public policy, the Supreme Court said we have to be really careful here. We can't incentivize people to trespass on land. So we effectively should be creating a deterrent for them. But we must look at how big the trespass was. What is the degree of trespass? So that it's very clear from Webb that the conduct and the attitude of the trespasser is examined, and it may affect the level of compensation to be awarded. Now, in this case, Simon is a young boy, and that's why I asked you to focus on that. He's a young boy. He lives in the neighbouring land. He's out walking his dog. There's no trespass sign up, but it's fallen to the ground. It's very hard to argue that this is a flagrant act of trespass. And he's a young boy who walked over a poorly displayed sign. And it's a very minimal act of trespass. I think you're safe enough to say that. So if this is an item of national importance, Simon should be aware that you can imagine the defence of trespass is going to be raised, but based on the doctrine of legitimate expectation and the findings in Webb, it seems to me that it says, Peter, there should be Simon. If he was trespassing, he would still be entitled to some type of compensation on the basis that it was a minimal trespass. The second big issue here is if it's not one of national importance, which it seems it probably isn't going to be one of national importance because it's not like it was found miles and miles deep in the ground. So it's probably a relatively new piece of jewellery, but we don't need to hypothesize on that type of level. We just keep it general. If it's one of national importance, what we need to determine is if the item is found under or on the land. If it's found under the land, we have two pieces of case law here. Yules and Briggs, which is the locus classicus, and then the more modern decision of Waverley, Burrow and Fletcher. Yules and Briggs, a prehistoric boat is found 6 feet deep. I want you to remember that statistic. You need to put that into your answer. And that was determined to be found under the land. It wasn't an item of national importance, and that decision is exceptionally clear. If an item is found under the land, it is assumed to be affixed to the ownership of the land. So the freehold owner is the person who is the best entitled to an item that is not one of national importance, to which the true owner is not forthcoming, can have the best title to. A more modern decision then are Waverley, Burrow and Fletcher. This was a public park. This was another metal detector case. Metal detectors were massive in the 70s and the 80s. And in this instance, there was a gold brooch found 9 inches under the surface. That's very, very close to the surface. Because the defendant did have to dig 9 inches deep, the court found it was under the surface, it was not on the surface, and therefore the council who owned the park were the ones that had the best entitlement to the property. And again, it was not one of national importance. This is why I asked you to circle the words half-buried. Half-buried opens up a bit of a line of inquiry here. Was the jewellery visible to the naked eye? If yes, it's probably not a Waverley Burrow or a Yules v Briggs situation, so we'll deal with that in due course. But he does need to provide a little bit more instructions. Did he dig it up with his hands? Did he catch it with the naked eye? If he saw it with the naked eye, which he'd lead you to suggest that he probably did see it with the naked eye, it's most likely not an item that was found under the land, but he does need to be clearer, and we can give him advice on the assumption that if it were to be found under the land, it would be the true land owner that would have the best title. What's most likely occurred here is that the item was found on the land rather than under the land. You need to use 3 to 4 cases here. If you can put 4 cases in and you have the time, brilliant. If you don't, discuss your 3 cases properly. The lead case here is Parker and British Airways, which is our airport lounge case. And the idea is that it's generally not the freeholder has the best title, it's finders keepers. But something that's often overlooked in Parker is often people will say, well, Parker and British Airways says the following. It effectively says that if you find the item and it's on the land, you're the one that's entitled to it. There's a bit of a caveat to that, and it's clearly set out in Parker. If the freeholder, in this case British Airways, if they had been found to have had an intention, and the court says, and an obvious intention at that, to exercise an element of control over the land and all things on it, then there might be a stronger argument there that you are the true owner of all items on the land. Now, British Airways failed in that argument in that case. So what you need to do post British Airways case is look at the nature of the land. And you need to compare the facts of the National Crime Authority in Flack, where it was a domestic dwelling. She didn't know the bag of money was there, Mrs. Flack. It was in her son's bedroom under the floorboards. But it was her domestic premises, and the court said this woman doesn't need to know of everything that's in her property, but it's her home. She can be expected to have an intention to exercise an element of control over all the items on the land. Unlike FLAC, you've got Army and Delamere and Hannah and Peel, and in both of those decisions, that's the Hannah and Peel is the World War I decision, and then the Army and Delamere decision was the chimney sweep. And in both those cases, the finders are the keepers. So in looking at the nature of the land here, this is a cave. It's highly unlikely the freeholder can show that they've been exercising a high degree of control over the land. The sign that's on the ground is pretty indicative of that as well. And therefore, it's highly unlikely that a true landowner can succeed to the level that Mrs. Flack did. You're looking more at Parker and British Airways. If that is the case, then it seems that our client is the person that is most entitled to the item. But Mr. Burns or Simon's father may own the freehold of the cave. So whoever the freeholder is might argue they've the best title, but they'd have to argue that they were more like Mrs. Flack than British Airways. So it's very difficult to argue how the freeholder is going to win this argument. And it seems, subject to clarification, that Tim is not the true owner, that Simon has the best entitlement to the property once it's not one of national importance. Okay, so in your overall conclusion, don't forget you have to provide an overall conclusion. You must ascertain if the true owner is forthcoming. If Tim is not the owner of the item, you need to make inquiries into the status of the item. Is it one of national importance? If the answer is no, it's most likely the item will be found on the land, not under the land, and our client has the best title. So this is, as I've said in the slides, they're a very good example of how you'd have to qualify your advices. It is okay to go back to the client and say, I need clarification on this. Okay, October 2019 was a question on adverse possession. So just to be aware that adverse possession, there's no one way that this comes up. It can be an essay question or it can be a problem question quite easily. This essay question asked you to discuss the definition of adverse possession and to also look at reforms in the area. So it was a quotation that was provided and you had to discuss it. Now, always when adverse possession comes up, the quotation is really asking you to deal quite a lot with this idea of the animus possidendi, that third limb of the adverse possession test. Why? Because the Irish law is still in a bit of a state of flux in its high court decisions as to whether the intention, the true intention of the true owner needs to be taken into consideration for that final limb of the test, the animus possidendi. So in discussing adverse possession in an essay context, you're actually going to end up discussing it in a very similar way to what you'd use if you were discussing it in a problem question context. So when preparing for this question, you can pick either an essay question or a problem question to practice because you're going to hit the same parts of the test each time. We don't have a statutory definition of adverse possession, but the time limits for causes of action in relation to land ownership are set out in section 13 of the statute limitations. So we'll go through the time limits and they must show that they've been on, the squatter must show that they've been on the land for the requisite time limit. Then they have to show that they have possession, that it's adverse, and that they've got animus possidendi. And as I've said there, the jurisprudence is split on that final element. This idea of adverse possession is very, very married to property law's obsession with the market economy. So it's this idea of gaining de facto rights in someone else's land through long possession. Why do we want adverse possession in a modern property law? We don't want land falling into dead hands and not being used and not being regenerated, because why? It's bad for the market economy. So the time limits for adverse possession are 12 years, 30 years and 60 years. And remember, 30 years is for state-owned land. And please remember, this is very important, that state-owned land does not include land owned by a city or county council. 60 years then for foreshore land, which is land between high tide and low tide. Okay, so you'd be providing either one big or two small introductory paragraphs here, and then you'd be setting out your idea of what you think adverse possession is. Obviously, you're not expected to verbatim insert quotes. I've just put it here for the purpose of this lecture. In most adverse possession decisions, you actually see judges quote this quotation from Murphy and Murphy, where the court says adverse possession means possession of land which is inconsistent with the title of the true owner. And that inconsistency necessarily involves an intention to exclude the true owner. That's very important. And all other persons from enjoyment of the estate that's been acquired. Adverse possession requires that there should be a person in possession in whose favour time can run. So that would be the true landowner. Okay, so then what you would do is actually quite straightforward, and this is what I mean by a problem question and an essay question being very similar. You'd always stick to the same structure here, where you go through the three-part test for adverse possession, adverse, animus possidendi. For possession, I think you need about 2 decisions here. There's plenty of decisions. In city colleges, in the lectures we focused on Molly and Fee, Thorpe and Frank. There's obviously that seminal decision by the then Judge Clark, former Chief Justice of Ireland, in Dunn in the Iarnród Éireann decision. That's an incredibly important decision as well. Molly and Fee was the decision of Judge Lafoy, where there was somebody squatting on the land, and this judgment is good because it talks about the degree of possession, those degrees of control, these acts of possession. How strong does your act of possession have to be? And we know from Molly and Fee that the act of possession for a squatter needs to be much more stringent than an act of possession or ownership of the true owner. So, for example, in Molly and Fee, the only thing the true owner did was bring an auctioneer to the land to value the land, and that was enough on that occasion to set the clock back to 0. So a very low level of control being exercised there. In Thorpe and Frank, that's an English Court of Appeal decision, a relatively recent decision that shows how adverse possession would work in a residential context. This was a forecourt area between 2 residential premises, and you could see that Mrs. Frank had effectively been paving and maintaining a very small concrete forecourt area, and she de-weeded it every few years, and that was considered to be enough for elements of control in that residential context. Dunn, Iarnród Éireann, you'll see that he was storing animals on the land, but he wasn't the only person doing that. There was children playing on the land. There was people placing chickens on the land. So just, again, always look at the type of property. And if it's a problem question, is your client exercising elements of control over the land? Are they acts of possession? And are they strong enough to meet the threshold? Those acts of possession must be, moving on to the second part of the test, adverse to the true landowner. And our lead case here, and you'll see this in every exam report, is Battelle and Pine Meadows, where effectively what had happened here was Battelle's had asked the predecessors and title of the defendants, who were called Cranford Limited, could they use part of the land as a vegetable patch. The predecessors and title said, we don't know if we even own that part of the land, we don't really care. They didn't carry out any inquiries, and they apparently acquiesced to the Battelles setting up there. When the successors and title came along and they looked up their boundary line, they tried to effectively take the land back. And the Battelles successfully won an adverse possession claim there, because they effectively said, we didn't have permission to be on that land. We had no license to be on it. Permission is not acquiescence, so to speak. In this case, they were adversely squatting on the land because nothing was being done and no inquiries were being made by the predecessor and title. The third limit of the test is where you're expected to have a broader discussion here. So animus possidendi, something that students often get confused about in animus possidendi is there's what I call a controversial element to animus possidendi and a controversial element to animus possidendi. A non-controversial and a controversial. The non-controversial part to animus possidendi is effectively the idea that the squatter himself needs to have the intention to be on the land to the exclusion of all others, including the true landowner. And the lead case there is Murphy and Murphy, that we discussed about the son who was squatting on his mother's title, and he and his mother didn't even realise that the mother had a title in the land. So the non-controversial part of animus possidendi is that you must have the intention as a squatter to possess the land for your sole use. That's not controversial. What is controversial is that post the decision of Lee v. Jack, there seems to have been a tacking on to that level of animus possidendi, which would lead us to suggest that you, the squatter, need to also be working adverse to the true owner's intention. And we have a series of cases in this jurisdiction post Lee v. Jack The problem here is we've got a conflict of in the jurisprudence in Ireland. That conflict has been resolved in the United Kingdom or in England and Wales. And the whole idea is if I purchase the land and I hold on to that land for a future use, whether it's to build a motorway, build a shopping centre, build a street, as it was in Lee v. Jack, if I have a future intention for the land, can you squat on it if I didn't have any intention to use it for the time being? Are you really acting adverse to my interests? Now, most scholars would agree now that Animus possidendi doesn't concern the true owner at all. It's about the intention of the squatter and the squatter only. The problem here is these decisions that we have, Court Corporation and Jurek and Considine, are conflicting with each other. Lee v. Jack says you do need to take into account the intention of the true landowner, and if they have retained the land for some future use, you cannot adversely possess it because your presence can't be adverse to their intention. J.A. Pye and Graham is a House of Lords decision from the same jurisdiction as Lee v. Jack that says no, Lee v. Jack is incorrect. And that's not necessarily what Animus possidendi means, and Lee v. Jack is being misstated. So, for all intents and purposes, Lee v. Jack, as it's understood in Court Corporation and Lynch, has been overturned by the House of Lords. The problem here is Court Corporation and Lynch follows Lee v. Jack in this jurisdiction. Jurek and Considine and Fian and Leamy doesn't, but they're all High Court decisions. So we have an unsatisfactory situation in Irish property law at the moment where we don't have a Court of Appeal or Supreme Court decision on the matter. What we do have is a 1989 Law Reform Commission report that recognises this difficulty and ambiguity. It goes on to say the statute of limitations says nothing about Animus possidendi, nor does it state that we ever need to take into account the intention of the true landowner. So the Law Reform Commission has actually advised that there's an express reform made to the law that says that a squatter's possession only must be consistent with the title of the true owner and not with their intention. So that would lead us back to a J.A. Pye and Graham decision. You would be expected in an essay question to very much set out your opinion on this. If it's a problem question, you don't necessarily need to set out your opinion, but you need to set out that there's an ambiguity, and if you're taking this case, there's an ambiguity affixed to it. We await still a Supreme Court and a Court of Appeal decision. A Court of Appeal or a Supreme Court would be very influenced by the J.A. Pye and Graham decision. It would also be influenced by our former Chief Justice's comments in Fian and Leamy, and also the Law Reform Commission report will be opened up to the court, so you'd need to be aware of that. Now, it's very important when you're talking about adverse possession in an essay context to very much give an opinion. And if you don't know what your opinion is, you do need to have a think about it, because you need to probably have a look at the Law Reform Commission report and decide whether you agree with that particular finding. There is no statutory definition for adverse possession in our law. The only thing that is provided is the time limits in the statute of limitations. So maybe it's time that we actually put it on a statutory footing. Okay, moving on to our last question. It's from 2020, and it's a succession law question. And those that have done the course are very aware of how important I think it is to focus on succession law for the property law exam. Typically speaking, if you go back and you review the questions for property law, it has been always the case that 2 succession law questions have come up in the exam. And if you've gone so far as to read the reports of the examiner, whoever the examiner was on that particular year, they would usually state that the succession law was the most popularly answered question. So people seem to be well prepared for them. You can get an essay or a problem question. Sometimes it's 2 essay questions, sometimes it's 2 problem questions, sometimes it's 1 of each. You need to be prepared to be able to answer either and know every inch of your notes in succession law, because any aspect can come up. Often what happens is a question like this can pop up in the exam that has a bit of everything in it, or a bit of 3 or 4 different issues. So let's have a look at Jackie here. She died suddenly from a short illness in January 2019, and at the time of her death, she was living on the family farm that she'd inherited with her wife, Julia. So we know she's married. In her will, Jackie left all of her worldly belongings to her son, Matthew. Jackie also has a daughter, Mary, from a previous relationship to whom she's left nothing under the will. Upon discovering her mother's estate, or mother's death, Mary claims she was left out of the will and she did not get along with her mother. However, she does acknowledge that her mother did give her €14,000 10 years ago to start up a new business venture, which never took off. In fact, Mary was challenged by alcohol and drug addiction at the time and mishandled the money as a result. She's been in recovery for the past 5 years and she's currently unemployed, living in local authority housing. Matthew, on the other hand, is married with 3 children and is a wealthy dentist. So we're asked to advise Matthew and Mary. We're not asked to advise Julia, but we certainly need to be aware of Julia's rights. Okay, again, we have to provide an introduction before we jump into the ILAC approach. You'd set out here, for example, she's died testate because she's got a valid last will and testament. We do not need to look into the validity of that will. There's nothing in this question to suggest that section 77 and 78 haven't been complied with. That is not always the case, so be very vigilant of that. Irish succession law fosters this idea of testamentary freedom, and that is the idea that if you execute a valid last will and testament in accordance with the 1965 Act, you should be given unfettered discretion to dispose of your estate. But, and it is a big but, that full idea of testamentary freedom, that fully unfettered idea, only applies to unmarried and childless people, and actually those that enter into a civil partnership as well. So in particular, we're going to be looking at those restrictions that might present in relation to the freedom of testation and making it very clear we're not challenging the will here. The will is valid. We're looking at whether there's any statutory inroads. The first thing to point out to everybody here is that the deceased died testate, a married woman. And the Succession Act is very clear on this. So she seems to have excluded her wife from her will. But that's not problematic for Julia because Julia is entitled to a 1/3 legal right share under section 111. In addition to that, she may have a claim where she could appropriate the dwelling house in satisfaction of her legal right share, and that is section 56 of the Succession Act. So you need to set out what section 111 is. Remember, you're entitled to bring that piece of legislation into the exam. You've no excuse for not knowing it. It's there. She doesn't want you to verbatim quote pieces of legislation that you have in front of you. She wants you to effectively explain that section. In terms of the fact that no gift was in fact given to Julia, we need to look at O'Dwyer and Keegan and section 114 of the Succession Act. So if there's no gift left to Julia, which is the case here, there's an automatic vesting of 1/3 of the estate to the wife here. So if she were to die, for example, without having elected to take her legal right share, that part of the estate is still gone over to her estate. She can always renounce her entitlement. Of course she can. She's probably not likely to do that if she's living in the property. The other thing to take into account is that she has an automatic entitlement. It's not that she needs to bring a case here. It's very different from the children here. The difficulty here is she may appropriate the family home, but it is a farm. So just remember the comments about section 56. Section 56 says you can appropriate the dwelling home in satisfaction of a legal right share, but if it's on agricultural land, you'd have to make an application to the court. But all in all, she's still entitled to 1/3 of monetary value of the estate. There's nothing anybody can do about that here. And everybody involved needs to be aware that if they are going to dispute the estate, it's only 2/3 of it that's up for grabs. Dealing with Julia's right to appropriate the dwelling. You could amalgamate this all into one paragraph. I don't think you should do that. I think you just set out the section 111 and 114 and then deal with this appropriation of the dwelling. Section 56, as I said, it's set out the exceptions. You have that section in front of you. Have a look at subsection 6. It includes agricultural land. She would need to bring an application to court. Now, what would she need to do? There's actually not a lot of case law on this, but the decision of HVH is the one that we cite in the manual. And what we do know from that decision is, first, the onus of proof is going to be on the spouse that's seeking to appropriate the dwelling. Second, what they would need to be doing is they would need to be assuring the court that by appropriating the agricultural land, it doesn't overly diminish the value of the estate. Now, we just don't have any statistics here as to the value of the estate and how much the property is worth. So, and you never really are in the FE1s given that level of information. So we don't need to be concerned about that. We just need to say she'd need to bring an application. There's a bit of an issue here because it's agricultural land. We don't know if she'd be successful, but what she'd have to show is she's not overly diminishing the value of the estate. We don't have enough information here, but what we do know is she's getting 1/3. either way, whether it's through real estate or cash assets, she is getting mortgaged. Issue 3 then is the possibility of Mary's claim. Now, if you dealt with Mary's claim first, it wouldn't have been technically wrong, but you wouldn't have been providing the context for Mary, which is she can only challenge 2/3 of the estate. So what she would be effectively saying is she's been excluded from her mother's will, and that she feels there's a failure of moral obligation to make proper provision for her under the terms of her mother's will. She would be making that claim under Section 117. 117 is very different from Section 111. And you would be saying to Mary, unlike a spouse's rights, there's nothing automatic about this. There is no obligation to leave anything to any child. These are very, very subjective applications. The onus of proof is on you. It's a very high one as per ABC deceased. And the litigation tends to be bitter and long running. There's plenty of case law here. As I've said in the lectures, you really have to at least use IAC and ABC deceased. FM and TAM is a good decision as well, because it goes to show that it's case by case, it's family by family, and the court will be very focused on the financial provision that was given to Mary in her lifetime. Now, the fact that she has dependency issues works both ways here. She may be viewed as being a vulnerable adult, and therefore there should have been heightened care for her, or the court may say, this deceased lady has done as much as she can for her daughter, who has her own personal difficulties, but she's discharged her moral duty towards her. And the fact that she has dependency issues cannot be a prolonging the issue of moral duty for the deceased. The difficulty here in that decision, in that line of thinking, is her brother is very wealthy. Her brother has less need for provision from the estate. They seem to have had a poor relationship, the deceased and Mary, but MacDonald and Norris looks at the conduct of the parties and makes very interesting comments about how often fighting children with their parents is because they are from the same genetical background, and that is why they are fighting. ABC deceit is obviously really important because it enforces the entire test, and there's plenty of different elements of ABC deceit that you could have taken from that to apply to Mary's case. In applying the case law to Mary's case, what we'd have to acknowledge is there is provision to her to some extent in her lifetime. We certainly need more information from her as to her level of education, what her income would be. Is she married? Does she have a spouse? What's her spouse's income? Has she got dependent children, for example? And it's clear that the deceased did have other people that she needed to call to mind to at the time of drafting her will, such as her wife and her son. The fact that she didn't provide for her wife is kind of a separate issue. She still had another person to call to mind when she was drafting the will. Having said all that, as I've already pointed out, Mary will be classed as an adult with a vulnerability, and that will be taken into account. And really the issue to be determined is Mary's conduct, the causation of the separation between them. Is MacDonald and Norris going to come into play there? And it'll also take into account the fact that parents are assumed to have known their children best, better than a court. And the role of the court is not to sit in the shoes of the testator and done what they would have done or done differently to what they've done. They have to look at the lifetime of the deceased and whether there was a discharge of moral duty in the lifetime. What I mean by that is, if the moral duty is discharged through your lifetime by your parent, you don't have a claim under 117. It's not that you need to be left something. And just because your brother or your sister or your auntie or your uncle or your father or your mother has been left more or everything under the will, that does not mean you have a claim. What's very in favour of Mary's application here is the position of her brother Matthew, though, and he's very comfortable in life, so you'd be pointing to that. The other thing to say about generally with these succession law questions is it's very rare you don't need to bring spousal rights up and children's rights up. And just to be aware that sometimes it might affix to another question as well, where there might be a promise made by a deceased. Now, if a promise is made by a deceased, which wasn't the case here, Section 117 and ABC, the case law in particular, is very clear that that might be a special circumstance in the case. But in addition to that, you might have to contemplate whether there's a proprietary or promissory estoppel claim at play there as well. Just be aware of that in the overall context. So that is the 3 proposed questions that we're going to go through. They obviously accompany the notes. Go through those notes there, and I hope they assist you in your studying. And I hope that the written notes as well assist you in your study. And I wish you the very best of luck. This is certainly an exam that you can score quite well in. What I would implore everybody to do here is have a read of all the available examiners' reports. They're incredibly detailed. Particularly Dr. Ashton Parks has written very helpful examiners' reports, and I would urge you to have a read of them. Thank you very much, and I'm wishing you the very best of luck on the day of the exam. Thank you for joining me.